Court does call the case of Judy Weinberger versus Chelsea Cotterman.
Chelsea Cotterman present, Your Honor.
Your Honor, Robert McCoy appearing on behalf of Judy Weinberger. Your Honor, this case was scheduled for 2 hearing dates, the 26th and the 2nd. Ms. Cotterman was not present on the 26th. This is a termination hearing, a request for possession, Your Honor. We had filed a complaint for possession, and the court scheduled the 26th and the 2nd. We had been in this case for a while, Your Honor. We're trying to get some resolution to this matter.
Starting on case 2412. Ms. Cotterman, what do you say to the termination of tenancy provision complaint? That's the new one.
So I did mail and sign in a lease that she's emailed me. So I did sign it in through the U.S. Postal Service. So and I emailed that to you the last time we were in court. And so I'm also still under Sarah, and they are asking for something on her part, but she hasn't sent them anything since January.
Okay, so just stop for a moment. So part of the problem, Mr. McCoy, is that this termination notice was sent out. We were at the last hearing, and there was a lease that was sent out.
And she is not interested in renewing a lease with this tenant, Your Honor. This is the termination of tenant.
But here's the problem. Look up the case of Park Forest and its subsequent cases. She sends out a notice to quit, Park Forest versus Blackman, in any of its prodigy cases. She sends out a notice to quit, but then sends out a lease that by its very nature will invalidate the notice.
She did not send out,
the tenant signed it or not.
Your Honor, she did not send out a notice, a lease.
Yes, she did, because it was in my email, and I already emailed it to Your Honor's person.
Your Honor, that was part of Sarah's request to pay back rent. That is not something that was for renewal of a lease. This tenant has been in this property, and she has...
Mr. McCoy, you can yell all you want. I have to rule by the law. Your client can't do that. You can't send out a notice to quit and then send out a lease and expect the notice to be valid.
She did not send out a lease after the notice to quit, Your Honor.
Ma'am, who'd you send that to? Seems like Groundhog Day. Who did you send that to? Miss Cotterman? You said you emailed it here?
Yes. I don't know her name. It was one of your assistants that was during the court process.
All right. Let me just make sure I got it. I just wanted to see it. There it is.
Yeah.
And that. And ma'am, did you sign this and send it back?
Yeah, I sent it to the U.S. Postal Service.
And Mr. McCoy, you're indicating your client did not get this?
That's correct, Your Honor. I apologize, Your Honor, if it appears that I'm speaking loud. It may be because the computer is on high volume.
All right. All right. That was Saturday, July 9th that she sent it. is at least Ms. Weinberger indicating that she sent that lease on July 9th?
Yeah.
Yeah, she sent a lease on July 9th to Sarah to recover some back rent, Your Honor, at their request. But there was no intent to renew.
Has Sarah paid?
Sarah has not paid Ms. Weinberger any money since January of this year.
Aaron, is there a Sarah application?
There is. It's with Carmen at Hawk. The last note that I have here was, let me see. She was seeking clarification from Ms. Weinberger if Ms. Cotterman was still living in the unit.
What date is that?
That is August 22nd.
Do you have the application date of the Sarah application date?
I do. Just 1 second here. This was submitted in January. This is the one that we had to pull back from MSHDA.
Got it. You can't see, can you, Aaron, when certain documentation and other things were presented?
Depending on if the reviewer uploaded it or not. Are you looking for the lease itself?
I'm looking for when did the lease get presented to Sarah?
I'm not seeing that uploaded, unfortunately.
Mr. McCoy, did your client present a lease to Sarah?
No. Other than the original lease, no, Your Honor.
So in July, she didn't present a lease to Sarah?
Did you present a lease in July?
Asking me, Judge, or?
Well, you don't know because you don't have the notes, right?
Correct, yeah.
Okay. I'm asking whether or not plaintiff can tell me.
She don't have any recollection of presenting a lease to Sarah, Your Honor.
All right, but somehow or another, she was waiting on Sarah funds?
She was trying to get back funds from Sarah, but Sarah has not presented her with any money, and this whole case
okay,
was...
but she signed up to be in the Sarah program, correct?
That's correct. That's correct.
Okay, so here's the problem. The problem's going to be, I don't think she can proceed on this. First of all, there's going to be the notice issue, but maybe there's a way around that. But then there's going to be the presentation of the lease to the tenant, which I still am at a loss as to why this lease went to her. But then the other issue is with the Sarah funding, she's really not supposed to be then terminating the tenants in this fashion.
The lease ended, Your Honor. So the issue is whether or not, under any circumstances, can she receive possession of the premises. The lease ended actually in June 30th. And so, and at the time that the lease ended, the tenant had her boyfriend living with her in violation of the lease. She was supposed to be there by herself. And so, and this whole situation had caused her to lose a lot of money. And so what she's trying to do is get possession of the premises back and to repair it.
Mr. McCoy, on July 9th, have you seen what your client sent out?
No, I have not yet.
Your client sent a pre-signed lease. And I now have a defendant that's saying she executed that lease.
But I don't have anything.
She does not have anything executed, Your Honor.
But she at least executed it, right?
Yeah, she signed it to get back Sarah funds, Your Honor, and the purpose of that was that they had requested that she present that to get funds. And so she presented that lease.
Okay, so here's the problem. I don't know that she wants to make that argument.
Well, Your Honor, she was responding to them, to trying to get the funds that was owed.
Okay, let me just go through this real quick. She can't, and it never has been the case since the beginning of the SARA program, that a landlord could create a sort of residential circumstance to receive any funding and then kick a tenant out after the money is received. Because at some point she got paid some SARA funding.
But currently there is no lease, Your Honor.
And that is going to be a factual dispute. Because I have the lease before me right now. I have the lease that your client sent to Ms. Cotter. Ms. Cotterman indicates, and it is pre-signed by your client, Mr. McCoy, which I quite frankly cannot think of any time that I've ever seen that occur. And then Ms. Cotterman indicates she has signed it and sent it back.
My client has not seen anything from her, Your Honor.
Yeah, my problem with that is the client also said she didn't send a lease before. And now she's saying she doesn't have the one that Ms. Cotterman sent back. But I'm going to have no choice but to set this matter for trial on this issue. Because if there's a lease there, you're out. I've never seen anybody make this is an absolute mess. And if her sole intent was to get funds but kick the tenant out, Mr. McCoy, I'm just going to caution you on making that argument, because that could be an argument which is tantamount to some type of fraud on behalf of your client.
Your Honor, if
I'm just making, Mr. McCoy, I'm just making that statement. If she wants to make that argument, go at it.
Your Honor, if she's following the direction of Sarah.
I don't know that that's going to be your position, Mr. McCoy, because I get the feeling that every time after you talk to your client and we get here, that changes. Because before I was told there was no lease sent out. Now Ms. Cotterman has sent me a lease which is signed by your client. Now there's a reason why that's there. And now there's Sarah funds that are pending, but because Sarah hasn't gotten around to processing the whole thing, she's trying to kick her out before the processing of the Sarah funds. There's just a whole lot wrong here. A whole lot.
Well, Your Honor, I am assured that my client is trying to follow Sarah in doing things properly. And what we are interested in doing is to have Sarah talk to my client and myself and try and get this whole issue resolved prior to any hearing, Your Honor. But the fact of the matter is, currently there is no lease.
Especially. Go ahead, what?
You know, the other issue, Your Honor, is the water damage in this 2-apartment complex that is still out there. And Ms. Cotterman would not let the landlord in to finish the repairs.
The landlord got in. I ordered it.
You one day, Your Honor.
Come in. We went through all of that. Then your client didn't turn back on the water. Then we had to get the water turned back on.
No, Your Honor.
No, I don't crawl under a mushroom and then come back and it's a brand new day. I remember stuff from before.
Your Honor, if Your Honor would just give me an opportunity to explain what occurred. And so my client went in one day, fixed one of the items that was damaged, and that the other item that was damaged they had to tear the floor out underneath the unit to finish the repair. The person would not let the landlord back in to complete the repairs, and has since tried every way possible to not let the landlord finish the repair. The repair is not complete. The water has been on, Your Honor. So the water is on, but the problem is the place is not repaired, and the floor underneath that place is damaged and is causing damage to the apartment unit beneath that. So, I mean, we can look at all of this, but we need to get the place repaired so she can finish the repair work that's necessary for both units. The one that Ms. Cotterman is in, and the one beneath Ms. Cotterman. Your Honor, and we can meet with Sarah and try and identify the issue that is present with respect to direction that my client was following.
Mr. McCoy.
Yes, Your Honor.
I have been dealing with Sarah cases since the inception of the Sarah program. I will just tell you that if you provide the lease or don't provide the lease, they are giving information, I guess, to both clients in terms of what they need. If somehow you're indicating that somehow Sarah misled your client as to the rights and obligations, her rights and her obligations, then you can argue that, have at it. I don't know how long I'll sit there and listen to it, because that's not the way it works.
Well, Your Honor, I want to make sure that we understand what the issue is. I mean, you know, we apparently there is a lease that Sarah has, that you have, that's signed by both parties. And my client is saying she does not have that lease.
Does she have her email from July 9th? She's the one that sent it.
I have my email of me sending it, not of her signing it.
She have an email, she believed, of her sending it, but nothing with her signing it.
It was not returned by email. It was not returned.
Let me tell you what. Aaron, could you please have someone from, I think this was pulled back from Mischief, and Hawk has it now.
That's correct.
Could you please ask somebody there to prepare for the court a chronology of events as to what has occurred or wherever they may have those notes so that the court can have them as to what happened? Because I have a feeling as to what happened, somebody's not going to be telling me all the truth. And I'm just
do so.
And
Yeah, I'd like to get a copy of that also.
well, I'll see it, and whether or not they're going to be claiming any privilege on it, I'll get a copy to both sides, but the court's going to see it first. Folks, you're all wonderful people, but I'm sick and tired of dealing with you. Bottom line, I've been dealing with this thing since the first hearing in May. And there have been accusations back and forth regarding payment of monies directly to the tenant that weren't supposed to be paid that way, or at least an offer to the tenant of ceremony, which might in and of itself have been a fraudulent act. Then there's water in the house, to which, just so that we're clear, back on July 8th, the day before the lease went out, I had to indicate, because the water was not on, that under the statute for tortious interference with the tenancy or interference with the tenancy, it's basically a forcible lockout, that the plaintiff, as of that date, there was $1,600 at $200 a day owing because she had interfered with that. I needed the status of the DTE bill. Sick and tired of dealing with all this. Everything becomes this little shell game on this. And I'm just going to get to the bottom. People are going to get here, and everybody's just going to have to put up or shut up. I'm going to set a non-jury trial in this matter. And I'll hear both cases at that time. I'm going to set that non-jury trial for, is that the preferable day? Is the preferable one. For Monday, September 12th, 2022, high noon, 12 p.m. That proceeding, folks, is in person. I do not think that this is a proceeding that should occur via Zoom.
Thank you, Your Honor.
You understand that, Ms. Cotterman?
Yes, Your Honor.
We'll see everybody then.
All right, thank you.
We'll have bells on, ready to go.
All right, see you.